Massachusetts Department of Correction et al.
Right.
Good morning. May it please the Court, my name is Joel Thompson. I represent the plaintiffs here on appeal, and I'd like to reserve 2 minutes of my time for rebuttal. We're here appealing from a grant of summary judgment to the defendants in a case involving 5 prisoners challenging a policy change within the Department of Corrections made by the DOC and its medical contractor, and it was an extraordinary change for several reasons. First, it singled out a class of prisoners, HIV patients. Second, these patients had had medications on their person, or at least available. They were eligible for the Keep On Person program for over 10 years before this change was made. And third, it was based on an allegation at the time that these patients could no longer be trusted to take their medications, that they needed to be monitored and in a very paternalistic way. They needed to be babied into taking their meds. The record reflects that is just not the case. That is not what was happening on the ground.
Let me ask you about that, because as I understand the evidence, after they made the switch in the initial time frame, there was something like a 13% increase in patients showing no detectable viral load, although that wasn't a long enough period based on your expert's testimony to be statistically significant. But over the long run, by the time they tested, there was an improvement that your expert has not said is not statistically significant. So it sounds like the health of the HIV population, at least according to one major indicia of health, improved noticeably as a result of the change. How do you deal with that?
In a couple of different ways, Your Honor. First, put things in context. The starting point was a point of 80-something% undetectable viral loads before the policy change. What our expert says is, if you want to see what the effect of this policy change is, you better look to the period immediately before and immediately after the change, because that's about the closest you're going to get to controlling for other factors. And that change, although there's a slight uptick, he says when you run it through statistical models, it's not statistically significant change in viral loads. What the defendants rely on is that 3 years later, in 2012, there is a more significant change to whether 90-something% of patients do have undetectable viral loads. And what we submit is, and the expert agrees, is you can't trace that to taking away Keep On Person medications because there's too many other things that happen. Most notably, prisoners come and go, so the patient population is different at that time. Secondly, new medications came online, or new formulations of medications in 2008, 2009 that have changed viral loads everywhere, and it's no surprise at all that it changed things for the better in the prison setting also. It's not, but again, going back to the context and to the time of the change, there wasn't a problem that needed solving with viral loads, and particularly because under the Keep On Person program, individual patients who are struggling, whether because there's objective evidence that they are not taking their medications, or because their viral loads, their CD4 counts, their medical testing is showing a problem, one way or the other, they can be taken out of the program.
But when you say there wasn't a problem, if I hear that in one scenario there's an 83% who are meeting the key criteria, and in another scenario it's 95%, I would think someone would be suing the prison if they weren't achieving the 95 when they could, as opposed to the 83. And I understand you say, well, maybe other things explain the improvement, but whose burden is it to show that the confounding factors may or may not have explained the improvement?
Well, regardless of the burden, we can meet it if it's ours with with our expert testimony and with the provider testimony.
Let me ask you about that. You haven't met it. There's no statistical analysis. As I read your expert, he's simply saying other things could explain this. And you've mentioned two of the things.
Right, and as a result, because we're not dealing with a randomized controlled trial, it will be impossible to, go back in time and, if you really wanted to know the answer to the question about the Keep on Person program in that sense, to that degree of definiteness, you would have to split the patients up in half, take Keep on Person away from half.
But I don't think, how can the legal standard be one that unless prison officials do scientifically controlled studies that would get peer-reviewed and published, they can't sit back and make the common sense decision that 83% healthy, 95% more healthy or healthy. Why wouldn't we be insisting that they do the latter, not, in fact, claiming that they breached the law by doing the latter?
Well, for a couple of different reasons. Just staying with the medical claim, which is the Eighth Amendment claim, because there's a substantial number of people who had undetectable viral loads, had great CD4 counts, completely stable, who were not missing medications before the change, who have missed medications or have had dosing errors since the change, and so their care has gotten demonstrably worse. There's testimony from the HIV specialists that they have had to change regimens for some people who have gone detectable in their viral loads. The risk of the viral load going detectable for these people who it hasn't happened yet, but it can happen. It's hard to say exactly when, but it can, and the risk of future harm is what is, bothering our plaintiffs and many others in that class.
But the essence of your Eighth Amendment claim, counsel, is that the Commonwealth was deliberately indifferent to these medical needs. The record here appears to exhibit the exact opposite of indifference. The prison recognized a problem, both a problem with some prisoners not taking the medication and having no effective way to police that, and also a problem with the amount of resources that were being consumed by this medication because there was no way to recapture and reuse medication that was given the prisoners and not taken. All right? They studied the problem. They came up with a solution, which whether or not it's the best solution is not a solution that indicates to me they were indifferent to anything. They attempted to come to what was a plausible solution to a problem, and the results of the solution, on the whole, not for everybody, maybe not perfect, maybe not peer-reviewed, but the results of the change seem to have been generally favorable. Not only the favorable change in viral loads, but the favorable change in the economics, which was one of the which freed up more resources for the patients. So I struggle with the notion of how this can be deliberate indifference.
Right, Your Honor. Well, we take issue obviously with the savings and the amount of the savings and identifying who's responsible for the waste and where that money can be recaptured. And the people, again, the actual providers in the prisons giving the care had tracked those return medications and said.
But under the deliberate indifference standard, the test isn't whether in some academic sense the Commonwealth is right or wrong. The test is whether their decision to handle the problem in a particular way is reasonable and doesn't work an unconstitutional or undue deprivation of needed medical treatment for patients. Patients are receiving exactly the same drugs if they want to accept the regimen.
They are, Your Honor, but like I said, there are for a number of the plaintiffs and for a number of these HIV patients, it went from better to worse, and you can identify who those people are.
But let's stick with that. Even that's puzzling me, because if it was 83% before, then that meant there was 17% who had undesirable viral loads. If it then went to 95%, then there's only 5% left. So mathematically, very few people in the 83 could have moved over to the 5, a maximum of 5, if everybody else in the 17 got moved on top of the 83 minus the 5. So I'm having trouble seeing that, and in any event, what standing do your clients have to complain about whether there was someone else?
Yeah, and they are doing fine now. We acknowledge that they have undetectable viral loads, and they're doing their best to get to Medline. What we stand on with the Eighth Amendment claim is the risk of future harm to them from these hiccups. One of them did go detectable right after the change. Peter Poe, he came back to undetectable. I do want to turn my attention to the ADA claim because I think it is different substantially because it's not as fact intensive in that way as regards to treatment. It's that, quite simply, the Keep On Person program is a program. It's one that doesn't have to exist in the prison system, but in this prison system it does. It was afforded to these patients, and this does, somewhat intersect with the medical claim in the sense that the medical providers on the ground, they check the medical records, they check the medication logs, they meet with the clients, they take a pill count, they pull the people off of KOP if they need to be pulled off of KOP. Now nobody can have KOP, and that includes a whole lot of people who...
Wait, counsel. You're saying that under this record there's a complete exclusion from those from the KOP? I thought in reading the briefs it was only as to the medication for the HIV.
That's right, Your Honor. So it's just as to the HIV patients.
But they're not excluded from completely going to the KOP. They, for other medications, still are allowed to participate in that, aren't they?
For anything else that's eligible for antibiotics. It wasn't aborted
completely. They still participate to some, but in regards to the HIV medication, right, that's what they were brought to be.
And it's the HIV medication, which is the life-saving medication, and which is the one that's most important to have on a daily basis. It's a program, like I said, that was qualified for and it was earned and held by all 5 plaintiffs and many, many others. And the defendants keep coming back to whether an accommodation is necessary to get to Medline, and that's not really the claim. The claim is that this is a category of people who are being discriminated against, just as if they had been denied a kitchen job. If kitchen jobs were denied to all HIV patients.
You're saying there's a program there, and patients with one type of disability can avail themselves of the treatment they need in that program, but patients with your client's disability cannot avail themselves of the benefits of that program.
That's right.
Do we have, it wasn't clear to me in the record, what percentage of the administrations of drugs occur through KOP and DOT? Because it's not just HIV that is limited to DOT, as I understand it.
Right. There's a list of drugs. It's in the Keep On Person policy.
And we've got a list of drugs, but what's that translate into real terms? If we take each pill being administered to each person, how many through DOT, how many through KOP?
There's no chart to that effect. In the record, there was testimony from the case managers for HIV about their patient population who said the vast majority of their patients were KOP. I think they each said they might have a couple here or there who were not KOP, either for reasons they were suspended or for reasons they elected not to be part of the program.
But isn't there also testimony that a substantial number of drugs other than the drugs for the HIV virus are on the DOT list?
Yes, there are other drugs on that list, but there are very few that have ever been KOP for over 10, in fact none on the record, have been KOP for over 10 years, and then summarily, as a category, as a class, taken away.
We've asked you a number of questions. If you have another point or two to make, go ahead and make it.
Only staying with the ADA claim that it's this program, Keep On Person program. It's hard to articulate the importance to the patients, but it is and was important. And there's testimony from the providers. It was important to the providers. That was a very it was a known, a very purposeful decision to make them part of the KOP program when HIV medications came out. So we're not dealing in a context where these medications are out in a vacuum. They came online in the 90s. they've always been KOP, and then as a group they were removed, and that's what we find to be discriminatory. Thank you.
Mr. Thompson.
Good morning. There was no error by the district court. This case centers on merely a change in the way medications were dispensed. It doesn't result in any substantive change in the medical care that are provided. And as the record shows, you can see that not only was this decision made after much effort involving a number of professionals over a period of time, representing the thoughtful nature that this would result in reduced cost, potentially adherence, and reduced waste. And that was the reasons they went forward. As to the substantive care, you'll see that every inmate that's HIV positive is assigned to an infectious disease doctor that they see either monthly or every 2 or 3 months. They're assigned to a case manager, usually a nurse that coordinates their care. They have access to the physician and nurse services that are provided to all inmates. Their viral loads and blood tests are followed and monitored closely. And all that's at issue here, despite the voluminous record that you have, is that they decided for good reason to believe that adherence would be improved, costs would be reduced if they dispensed it by DOT. And that's really what's before. And the costs here are not insignificant. In 2009, the HIV medications were between $4 and $5 million a year, $400,000 a month, representing 47% of the pharmacy services budget for 2% of the inmate population. I would suggest that it was their fiduciary duty to look into areas where they might be able to reduce costs, and it has turned out to be beneficial with no adverse effect to these inmates.
Do you have we talked about the statistics earlier with Mr. Thompson. What his argument is that we shouldn't place much weight on the 95%, because his expert said it really doesn't show that the change from KOP to DOT caused anything. It simply is an artifact of other confounding variables at operation here, such as change in medication, change in prison population. How do you respond to that argument?
I'm sort of a simple guy. I look at it as the marker to determining how well patients are doing as a general nature is this viral load data. And before the change, we have 83%, and after we have 95%. Can there be something to say, well, maybe it has to do with newer medications? Certainly that probably is the case. But the fact remains, and what they haven't presented is while they take shots at the pharmacy data and some of the claims data to say, well, it really isn't all that, not showing a lack of adherence for these long-term inmates. But they haven't shown how it's resulted in any adverse effect.
Well, let's pause on that, because it's not clear they do. I mean, if they showed no change either way, then how would you justify under the ADA denying access to the program to HIV patients, to the KOP program?
Well, I think, first, the ADA is aimed at prohibiting discrimination based on disability statute. By reason of disability, you can't exclude someone from a service or public program.
Sure. If they had walks in the yard, an extra hour in the sunlight as a new program as part of their physical enhancement program, and they said HIV patients can't do it, there would be discrimination against ADA that would need against HIV patients that need to be justified, wouldn't there?
Possibly, yes. There's not a penological interest.
And here they said if you have
served.
this particular disease, you can't participate in the KOP program. So why isn't that discrimination that needs to have some justification?
Well, they're not precluded from participating.
Well, they are. They are precluded from getting medications for their disease under the program.
Well, they're able to get medications that are covered by KOP. Some of the plaintiffs, for instance, blood pressure, aspirin, that are KOP, they're not excluded from that means of dispensing. Yes, the target here was HIV medications. And the reason for the change wasn't to discriminate based on HIV status. It was the belief that if they were dispensed DOT, it would result in reduction of costs. And there was a potential, a good faith belief that it would increase adherence. And I think that is a legitimate basis, and it's supported by the record that in fact has turned out to be the case. So this is not a case. There's over 67 medications that we've listed that are identified that that are not part of the KOP program. So I don't believe the ADA, the Rehab Act, is the construct for this case.
Counsel, while we're on the ADA, because you both have gone straight to the merits in regard to this, but I believe there's an argument that you make that they've waived the ADA claim. Is that right?
Waiver. I'm not sure if I
think that may go to the reasonable accommodation claim, Counsel.
I think it's right. It's one of the plaintiffs, Nunes. Really, out of the 5 plaintiffs, only one, Nunes, is claiming that he wasn't given or should have a trial over disagreement over accommodation. And the waiver there, thank you, Judge, was Nunes has taken the position. He's testified that the only accommodation he wants is to be able to attend, have his medications KOP. So in that sense, it's a waiver. As to the deliberate indifference, not only was it, I think, a thoughtful decision, but there is no evidence of adverse effect. And they spent some time in their brief and mentioned just a few minutes ago some of the aspects of why they think there's deliberate indifference. And I think there's a huge gap between the broad strokes that they make and then when you bear down to the record, it's just not supported. For instance, they claim that the inmates are suffering side effects and have had medication regimen changes because of the change. First, they don't proffer any expert testimony to say these particular patients are unnecessarily suffering side effects or having medication changes because of the change. They don't proffer that. The closest they come to is Dr. Brandsburg, a public health doctor, who says, look, in some of the treatments for HIV, efavirenz and atripla are medications that can be used and that they have a tendency sometimes to cause flu-like symptoms or dizziness. Okay. And he says that that's why it's generally they're allowed to take it before the bed so they don't have to experience those kinds of side effects. If you look at the record, and you bear down to the record, the only 2 plaintiffs that have any mention of any side effects are Plaintiff Coe and Doe. And if you look at those particular testimony, it just doesn't support any kind of possible suffering from side effects due to the change. Coe complained of, at one point, feeling pins and needles in his hands and some eyesight trouble, and another point, some skin redness. No claim of any flu-like symptoms or dizziness. The only reference he made to testimony to dizziness, he related to his high blood pressure medication. He actually thought the side effects were due because of the fact that he had his nighttime snack discontinued, which he himself testified he never bothered to follow up on. As far as any change in medication, he did undergo a change in medication, but it had nothing to do with not being able to take it at bedtime. He testified it was to provide him a newer medication to boost his T cells and lessen the side effects. In January, he had a medication change, but that was due to a skin rash. And the point of giving you that example is when you bore down to the record, it isn't the record support doesn't support the broad-based claims of unnecessary side effects or they're somehow suffering harm because of the change.
I asked Mr. Thompson if there was anything in the record that would shed light on the percentage of drug administrations that occur through KOP as opposed to DOT. Is there anything?
I think, I was thinking about that. I can't think of something specific on that. I believe there was testimony that psychotropic-related medications are a huge part of medication distribution. And they are all excluded from the KOP. I just can't give you the percentage.
Whose testimony was that?
It might have been Dr. Hamill. I'm not sure, Your Honor. I'm not sure. But I don't believe there's any specific testimony breaking it up that precisely. There was reference to the infectious disease doctors not being wanting the change. As support of their deliberate indifference claim. Again, if you look at the record, it just doesn't support any type of finding of deliberate indifference. The 2 doctors certainly were taken, depositions were taken. They testified, yeah, they thought that there shouldn't be any change, but they clearly, when you review their testimony, were advocating for the patients who were complaining to them that they didn't want this change, that they liked things the way they were. They did not in any way opine that any of these inmates are suffering adversely because of the change, because it's just not there.
Should it be for the fact finder to balance those doctors' testimony?
I think certainly where factual, not speculation, but broad-based facts rise to a certain level where reasonable minds can differ as to whether or not there's deliberate difference claimed, certainly. Don't forget in this case that the relief that they're seeking is, their only relief they're seeking is broad-based injunctive relief. They want the wholesale elimination of this dispensing, means of dispensing. And so I would suggest that the evidence would have to rise to a reasonable dispute over whether there's a system-wide issue here as to deliberate indifference, and the record falls far short of that. Unless the panel has any further questions, I would leave the remainder to the brief.
Yeah.
Thank you.
Thank you.
Just to address a couple of points raised, Your Honors. In terms of the other drugs that are not part of the KOP program, there is, I think, testimony in multiple places, not to mention the list itself, that these are psychotropics, controlled substances, things with abuse potential, either abuse for recreational abuse or abuse, the potential of self-harm, and that includes things like injectable medicines, things that require syringes. That's the class, that's the list of meds that are not allowed to be KOP, and that is, that again goes to our claim, particular ADA claim. HIV meds are an outlier in that sense. There's no evidence in the record that there's any abuse potential or any evidence that there was any effort at that. This is not about that. That's not.
No, but if you put a psychotropic drug on DOT and you don't have a problem with that, that's essentially because there's a good reason to dispense at DOT. Well, here the good reason to dispense HIV drugs DOT is because it's going to improve health and conserve prison resources to a substantial extent. And so if one good reason is okay to put a drug on DOT, why isn't another good reason also enough?
But first of all, those reasons are disputed in the facts, and second of all,
you dispute them on a conclusory level, but there aren't any facts that show. I mean, the evidence of savings is there. You may disagree with it, but I haven't seen any evidence that contradicts it. All right, the evidence of viral loads is there. There's no evidence that contradicts it. Yes, your expert says, well, other things may explain it, but that's not contradictory evidence.
Well, first of all, for purposes of the ADA claim, for them to discriminate against this class of patients, they now have the burden to prove that it's necessary for those reasons. Yeah. And second of all, with respect to costs, the only people who ever studied returned medications were the case managers, and they found that there are pretrial prisoners and transfers within the from prison to prison. That's responsible for any of the ways to the cost problems. Those are not patient problems. They can be solved and should be solved by DOC's own policy outside of this policy change. And second, same with adherence, that the HIV specialists and the case managers on the ground, not to mention the plaintiffs, all testify to the fact they were adherent. There were no problems that needed solving. There are disputes of material fact there. And like I said, if you're going to discriminate against the class as a whole instead of simply singling out the people who need to have KOP revoked, you need better reasons than have been come up with here, and the reasons that have been come up with here have been disputed. Thank you.